Thank you, Mr. Speaker. Mr. Speaker, for starters, and because not all members have read the judgment, allow me to read 3 paragraphs so that people are in tandem. Paragraph 504. We thus hold and find that the simultaneous holding of the position of Speaker with that of the leader of political party and the leadership positions in the ruling political coalition, as in the case with the current National Assembly, and the concluding part is this dual role is therefore unlawful and unconstitutional. Mr. Speaker, that is paragraph 504. The continuing 505. We hold that the Speaker was elected in accordance with Article 106 of the Standing Orders. The fact that he was a party leader at the time of his election could not invalidate his election. However, for the reasons we have given, his position as the leader of Ford Kenya or the leader of any other political office, for that matter, became untenable and inconsequential the moment he assumed the office of the Speaker of the National Assembly. He could not, and he has no capacity to perform any other functions as a leader of a political party or a political organ as long as he is the Speaker of the National Assembly. I've referred to 2 paragraphs, 504 and 505. That is on whether the court expressly found the 2 offices untenable. And I will be making a concession separately. Now, 508, and this is important because I think we are debating in ignorance, Mr. Speaker. 508, it is hereby declared that the question as to which party or coalition of parties is a majority in the National Assembly in the 13th Parliament was determined by the sovereign will of the Kenyan voters during the 9th August 2022 general election. It continues, Roman 2, it is hereby declared that the Honorable Speaker's ruling on determination contained in his communication of 6th October is null and void. Roman 3, it is hereby declared that the Honorable Speaker's ruling on determination, blah, 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 on the minority, again, is null and void. And finally, an order of certiorari is hereby issued quashing the Speaker's ruling. Let me now make my submission, Mr. Speaker. First of all, this matter did not go to court in vain. The contestation, Mr. Speaker, was your considered ruling of 6th of October. Once that ruling is quashed, you cannot then, Mr. Speaker, with due respect, come and say that no decision has been made. The consequences are 2. 1, the leader of minority becomes the leader of majority by operation of law, even if you do nothing else. But in this case, we have gone further. And under Standing Order 19A, Standing Order 3,
I'll add you 1 minute. 1 minute.
Mr. Speaker, under 19A is very clear. The majority party whip shall communicate the name of the members elected under paragraph 1 to the Speaker in writing. And that was already done by the Honorable Millie Mabona. That settles that case. Mr. Speaker, the only way we can start debating whether this decision quashes and changes the position of majority and minority is if we want to practice impunity. Mr. Speaker, and I agree with your observations, it is not in this forum to question the reasoning in the judgment. That must be questioned elsewhere. The only issue is it the finding of the court? And it is. And if we are to be a country that practices the rule of law, let it be appealed. But until then, let it be implemented. Let the Honorable Junet Mohammed be the majority leader. And it does not matter whether you are in government or not, because we are not debating who's in government and who's not. We are not debating the reasoning. Mr. Speaker, we are not even debating your election because we all participated. Some of us who are not in the other party still voted for you. So